This is the second presentation for week 3, and we are still busy with the validity requirements for the conclusion of a valid union. This presentation deals with the third validity requirement, namely lawfulness. Lawfulness generally means that the law must in all respects allow for such a union to be concluded. This rather vague indication of what lawfulness means can be clarified by saying that a union can be considered lawful if two questions can be answered in the affirmative. The first question relates to the parties individually. So we ask, is each party individually and separately allowed to conclude a union in general? With the second question, we ask whether there is anything that prohibits the parties from concluding a union with each other. To answer the first question, two issues must be considered. Firstly, the age of the parties, and secondly, whether any of the parties is already a party to a formally recognized union. For purposes of this investigation, we are assuming that the parties have reached agreement or consensus and that the first validity requirement has been satisfied. The question of age and when a person becomes competent to conclude a valid union was discussed extensively in the presentation dealing with capacity to act. Please refer back to that presentation to revise this aspect. The only thing that I want to add in order to clarify why this is also discussed under the issue of lawfulness is because of the minimum age requirement. The law prohibits girls under the age of 12 and it prohibits boys under the age of 14 to conclude a civil marriage or a customary marriage, and the law also prohibits any party below the age of 18 from concluding a civil union. So this is the reason why we would then also say if any such party attempted to conclude a valid union, that union would be unlawful. The second factor to consider is whether one party or even both are already spouses or civil union partners in other valid unions. According to the general rule, an existing union is an absolute bar or impediment to the conclusion of any other kind of union. Because a civil marriage in terms of the Marriage Act and a civil union in terms of the Civil Union Act are both by nature monogamous marital institutions, a person cannot be married in terms of any of these acts to more than one person at a time. If any of the parties are already in a valid union, that union must first be dissolved before concluding a new union. A person can also not conclude a marriage under the Marriage Act and then conclude a customary marriage in terms of the RCMA with a different person. Because a customary marriage may be polygynous, the general rule prohibiting the conclusion of other unions does not apply to customary marriages. The husband who wishes to conclude a customary marriage with another wife can do so, as long as the husband complies with the requirements of the RCMA. The husband can therefore conclude a second customary marriage without first dissolving the existing customary marriage. There is also another exception to the general rule that an existing union prohibits the conclusion of a further union, and this exception also applies to a customary marriage. When a couple has concluded a customary marriage and that same couple wants to convert their customary marriage into a civil marriage or a civil union, the couple need not first dissolve their customary marriage. There is an example on page 31 to further clarify this exception for you. To answer the second question relating to lawfulness, there are also two possible issues that have to be considered. That is the issue of sex and the issue of relationship. Where the sex of the parties are concerned, that's now the noun, not the verb, sex is no longer a general prohibition to the conclusion of a union. The sex of the parties only becomes relevant if the parties want to conclude a marriage in terms of the Marriage Act or a marriage in terms of the RCMA. I indicated earlier that neither of these acts define marriage in specific terms. However, references to husband and wife in both of these acts make it pretty clear that these acts do not allow marriages between people of the same sex. The Civil Union Act, on the other hand, is couched in gender-neutral terminology and refers to spouses and civil union partners without specifying the party's sex. The sex of the parties are thus irrelevant where a couple wants to conclude a civil union in terms of the Civil Union Act. But what would happen if a party wanted to conclude a marriage in terms of the Marriage Act or the RCMA, and that party had undergone a sex change operation? For example, if Samuel became Samantha after such an operation, would Samantha be able to enter into a valid marriage with John under the Marriage Act or the RCMA? Although it was not always the case, our law now recognizes a person's change of sex in terms of the Alteration of Sex Description and Sex Status Act. This means that after becoming Samantha, Samuel may now apply to the Minister of Home Affairs to change his sex description in his ID from male to female. The court was recently alerted to a problem concerning applications in terms of the Alteration of Sex Description and Sex Status Act. In the KOS case, the Minister of Home Affairs was taken to court because the Department of Home Affairs had refused to register a change of sex in a number of cases. All of the applicants involved in this case, whose applications had been rejected, were in pre-existing marriages under the Marriage Act. Home Affairs argued that since the Marriage Act did not allow for same-sex marriages, it could not register the change of sex because such a change would indirectly mean that applicants would be in same-sex marriages in terms of the Marriage Act. Let's use Samuel, who became Samantha, as an example again to illustrate the problem. Say Samuel married Julia before he had a sex change operation. This would be perfectly legal because they are of the opposite sex. However, once Samuel had become Samantha, it would mean that Samantha would be married to Julia, which of course would look like Samantha is in a same-sex marriage under the Marriage Act, which clearly is not allowed by that act. The court came to the assistance of the applicants and ordered Home Affairs to register the changes of sex. The court held that pre-existing marriages was not affected by the latest sex change of a spouse. The reason for this is because a marriage, like any other contract, had to be assessed for its validity at the time that it was concluded and not at a later stage. At the time that Samuel married Julia, Samuel was male and the marriage was validly concluded. The subsequent sex change cannot retrospectively now render the same marriage void. The court also held that there was no provision in either the Marriage Act or the Alteration of Sex Status and Sex Description Act which prohibited or contradicted such a conclusion. The second factor to consider when determining whether the parties are allowed to conclude a union with each other is the degree of relationship between the parties. Students often find these types of questions very difficult, but there really is no need to fear. Just follow the recipe I've presented here. Step 1. Identify the type of relationship which is applicable. Step 2. Know the rules applicable to the type of relationship. And step 3. Draw a conclusion. I will also post several questions on this on your discussion board, so you will be given ample opportunity to practice this recipe.
There are 3 kinds of relationships that can prevent the parties from getting married to each other. Firstly, blood relationship, also called consanguinity. Secondly, relationship through marriage or union, also called relationship by affinity. And thirdly, relationship through adoption. We will now proceed to look at the rules which regulate each of these relationships in more detail. how does one know whether two parties are related by blood? The answer lies in the fact that they share a common ancestor or forefather. So a brother and a sister are related because they share two common ancestors, their mother and their father. Cousins also share a common ancestor in the form of their grandparents on one of their parents' sides. When we talk about blood relatives, it's important to distinguish between blood relatives in the direct line and blood relatives in the collateral line. So how will I know who are blood relatives in the direct line? This is very easy. Throughout the line, there is a parent and child relationship. So if you look at this example which I've provided, if the bloodline starts with A and B are parent and child of each other. With every generation, a new parent-child relationship comes into existence. B and C are parent and child with each other, and C and D are parent and child of each other. In this way, a direct bloodline comes into existence. Imagine for a moment that you are child C. So your parent B is in your direct bloodline, and your grandparent A is in your direct bloodline, and so is your children and your children's children, and so forth. The rules regarding relationship which apply to blood relatives in the direct line is that blood relatives in the direct line are always prohibited from concluding a union with each other. You cannot marry your parent, you cannot marry your grandparent. Your parent cannot marry your child, or you cannot marry your child or your grandchild. What then are blood relatives in the collateral line? This is where parties share a common ancestor somewhere in their lineage, but they are not parent and child of each other. Have a look at this diagram. Imagine again you are child C. There you will see your own direct bloodline, grandparent, parent, child, grandchild. But you will also see another bloodline, which stems from the fact that the common ancestor, your grandfather, had other children. These will be your aunts and uncles who also had children, which would be your cousins, and so forth. Blood relatives in the collateral line can get married if they are far enough removed in relationship from each other. The rule here says that where both parties are removed more than 1 degree, at least 2 degrees, from the common ancestor, the parties can get married. A degree is another name for a generation. So you will see that each line in the diagram represents a degree or a generation. Would C be able to marry X? That means, would you be able to marry your aunt or your uncle? Let's count the degrees. From the common ancestor, you are removed 2 degrees from your grandparent. How many degrees is your aunt or uncle removed? Only 1. What does the rule say? Where both parties are removed more than 1 degree, therefore at least 2 degrees from the common ancestor, the parties can marry. This would not be the case, and you would not be able to marry your aunt or your uncle. But if you wanted to marry your cousin, that would be possible, because both of the parties, you and your cousin, are removed more than 1 degree, that is, at least 2 degrees, from the common ancestor. A relationship by affinity comes into existence where a spouse becomes related to his or her spouse's family through marriage or through the conclusion of a union. So if you have a look at my example here, you will see that husband H is married to W wife. W becomes related to H's family through the marriage, and H becomes related to W's family through marriage, even though I did not indicate W's family in this example. In the case of relationship by affinity, we also make a distinction between affinity in the direct line and affinity in the collateral line. This is still very easy to distinguish if you know the rules pertaining to blood relationship. So, if the persons are related to H in a direct line, that would mean that W is related to them by affinity also in the direct line. Therefore, H's parents, in this case A, H's mother, and B, a child from a previous marriage, are direct blood relatives of H, and also related to W by affinity in the direct line. The rule here is that if you are related by affinity in the direct line, you are prohibited from concluding a union with that person. So if H and W should one day dissolve their union by divorce, or if it is dissolved through death, W would not be able to marry A, and W would also not be able to marry B. Where a person has blood relatives in the collateral line, they are also related in the collateral line to one's spouse, but not by blood, by affinity. Here I change the example to include W's family. H is related to W's mother by affinity in the direct line. From the previous slide, you will already know that should the union between H and W be dissolved by death or divorce, H will be prohibited from marrying W's mother. But W also has a sister. Sisters are related in the collateral bloodline. So therefore, W's sister Y is also related to husband H in the collateral line by affinity. The rule if you are related by affinity in the collateral line means that a union is never prohibited. This would mean that if the union between H and W is dissolved by death or divorce, H would be able to marry his wife's sister Y. The final relationship which must be considered is relationship by adoption. In terms of the Children's Act, adoption creates a fictional blood relationship between the adoptive parents and the adopted child. An adoptive child can thus never marry his or her adoptive parents. The impediment or prohibition to marriage only applies between the adoptive parents and the adopted child. The adopted child may conclude a union with anyone else in his adoptive family because there is no blood relationship between them. So in this example below, you will see that C is the adopted child and X and Y the adoptive parents. C can never marry X or Y because of the fictional blood relationship, but C can marry Z because there is no real or fictional blood relationship between them. The adopted child will, however, even after adoption, still not be able to conclude a union with any of his original blood relations from whom he was prohibited to conclude a marriage with. So C will not be able to marry A and B or anyone else in his direct bloodline, or even anyone from whom he was prohibited from concluding a marriage in his collateral bloodline. On the Department of Home Affairs website, you will find a separate step-by-step outline of the process to be followed to conclude each of the 3 unions formally recognized in South Africa. The list here is a copy of the one that you will find on this website under the heading Prohibited Marriages. The list only appears under the process and requirements to be satisfied for purposes of concluding a marriage in terms of the Marriage Act. You will see also from this list that the marriage envisaged here only includes a marriage between persons of the opposite sex. Rather than including this type of list in your study material to memorize, we have tried to encapsulate the impediments and prohibitions based on relationship in the general rules, which was explained in the previous slides. If you have mastered the general rules, you can always come back to this list to test and see whether you know which type of relationships are prohibited and which are not. Many of the prohibitions based on relationship outlined in relation to marriages under the Marriage Act, as well as civil unions under the Civil Union Act, will also apply to the conclusion of customary marriage under the RCMA. It's very important to note, however, that the prohibitions for conclusion of customary marriages under the RCMA are determined by customary law. And what this means is that the prohibitions may differ depending on the community to which the couple concluding the customary marriage belongs. A customary marriage between 2 persons may be prohibited in one community while being permissible in another community. I advise you to consult the book by Rotenbach et al., Introduction to Legal Pluralism, to learn more about these prohibitions in terms of customary law. Where persons are prohibited from concluding a union with each other because they are too closely related to each other, those persons also may not have sexual relations with each other because they can be found guilty of the crime of incest. From Section 12 of the Criminal Law Amendment Act, you will see how this act defines the prohibited degrees of relationship. Therefore, the rules which we discussed in this presentation are also of great interest to other areas of the law, such as criminal law. For now, we are finished with the content for this week, and next week we will do the final validity requirement, namely formalities and also some customary law requirements. I hope that you found the content for this week very interesting, and I now urge you to work through your learning outcomes and proceed to the discussion board where you will find the questions for this week.